Okay, good afternoon. Thank you everyone for joining me this afternoon. And first of all, apologies that this has been rescheduled for various reasons for Christmas. For those of you that don't know me, my name's Richard Borrett. I am counsel at King's Chambers, and I practice in these days three main areas: clinical negligence, court of protection, and inquests. So this afternoon, my talk, which hopefully won't be too long, certainly less than your lunch break, will cover two of those areas. That's inquest and clinical negligence. What I'm going to do is a fairly high-level overview of inquests, mainly aimed at those of you that either haven't done them or haven't done many before, in terms of how they work, the structure of an inquest, the main issues that arise, Article 2, which I will cover in some detail, but I can't cover it in full detail because it's an enormous topic, and some of the practicalities of what the inquest is, how an inquest can benefit in the negligence case, and how we go about getting the most out of it from a clinical negligence perspective. So, in terms of inquests, the first thing we need to try to understand is the inquest process and how it operates is very different to civil litigation. Obviously, the most important difference is that it is not adversarial, it is inquisitorial. It is the coroner's investigation, and coroners will often be very keen to remind us of that. There are really three stages, and they are the coroner's preliminary inquiries, that is referral from the hospital or from police or whoever it may be, which may lead to an investigation, which may lead to an inquest. Now, 9 times out of 10, our involvement, my involvement, is only at the third stage of that, is once there is an inquest. Although technically the inquest is actually only the hearing itself, and everything leading up to that is the investigation. So sometimes the coroner will decide there needs to be an investigation. And that is the process of gathering information, the documents, witness statements, and that's the point at which we might have some pre-inquest review hearings. And then that usually leads to an inquest, which is a hearing, and that can be of different lengths. The reality is that coroners often hold inquests which are purely documentary. They often hold inquests which are very short and have no witnesses. But tend to be involved in the law-related inquests. Now, we don't generally need to get involved too much in how the case gets from the preliminary stage to the inquest, but this is how it happens. It starts off with preliminary inquiries. There's reason to suspect that the death was violent, unnatural, or it was in state custody or state detention, or there is any lack of authority as the cause of death. Then the coroner must conduct an investigation. That generally proceeds towards an inquest unless the evidence points to the death being not violent, unnatural, or not in custody. There is some, in terms of violent and unnatural, one thing that often comes up is the meaning of a natural death. And there's a little bit of debate in authorities about precisely what it means, but in very simple terms, a natural death is the natural progression of a natural disease. And the natural progression of a death can become an unnatural death, either by way of some input or interference from another person, or a failure to intervene. So, in one example, there was a young man child having an asthma attack, clearly a natural disease. However, there was a failure to send an ambulance, and that failure to send an ambulance was positive on the death. So clearly that became unnatural by virtue of that there was a failure to provide care and intervene. So usually we become involved at the inquest stage, which is that third stage. Before we get to that stage, you might have, I mentioned a moment ago, some pre-inquest review hearings. Lots of these things depend rather on the coroner's own approach, and different coroners have different ways of doing things. But in more complicated cases, it's very common to have a pre-inquest review, or even multiple pre-inquest reviews, which are essentially case management hearings, where parties can raise issues. The coroner can raise issues about disclosure of witnesses, witness statements, what the issues are. And all of that is leading towards the purpose of the inquest, which is to answer 4 statutory questions. Who died, when they died, and where they died are the first 3. And in virtually all cases, they are not controversial issues. They can be sometimes, but usually they are not controversial. The final, the most important question is how that person came by that death. Again, there's debate in case law and between coroners sometimes as to what exactly that means. On one view, it simply means by what means, what was the cause of death. But realistically, in practical terms, it has to mean more than that, because the coroner is going to be considering prevention of further deaths letters. And also, in most cases, if it were only what is the cause of death, then the post-mortem would be enough. So clearly it goes beyond that. How far beyond that it goes depends on the individual circumstances. But normally, if someone has died during an operation, clearly the how would include what happened in the operation. What was the procedure used? What was the anaesthetic used? What drugs were used? What antibiotics were given? All those sorts of questions. In Article 2 cases, which I'll come back to, the question is slightly wider. It's how and in what circumstances. Now, in a lot of cases, that is going to make very little, if any, difference to the scope of the inquest. But I'll come back and explain that in a bit more detail later. The coroner has a very wide discretion as to what is included in the how. And my view is it's always extremely helpful, particularly in more complex cases, to seek to set down in writing what the scope is. Now, that might be by reference to a list of issues. It might include a time scale. So it might be by reference to a particular condition. It might be by reference, for example, to the treatment of the deceased's diabetic, or it might be treatment of a deceased asthma from a particular date. It's often extremely helpful to have that written down so that everybody knows from the beginning what is and is not in scope. And also that's an opportunity to push that scope as wide as you can, if that's what you want to do, in order to investigate as much as you want to of the death and the circumstances surrounding it. So that's something that I would suggest doing very early on. And most coroners do that now anyway. They will provide an agenda for the inquest review, and that may have in it a view on scope. And I will quite often draft submissions that will say, well, the scope should be wider than that. It should be this as well. Or depending on who I'm at to the core, I might be saying it should be narrower. The coroner is not entitled to make any findings which may appear to determine criminal or civil liability. So that simply means that the coroner cannot come to any conclusion that says a person was negligent or in breach of their duty, or that a person committed a criminal offence. However, many of the conclusions do effectively do that. So, for example, an unlawful killing conclusion clearly is a conclusion that somebody has committed a criminal offence, although it would not name that person. And of course, it's on the different standard of proof. The standard of proof in inquests for all conclusions uses balance of probabilities. So actually, although coroners are very keen to remind everybody that they cannot determine criminal or civil liability, that does not mean that they cannot make findings that something has gone wrong, and that does not mean that they cannot make findings of culpability. Disclosure in inquests is very different to disclosure in other proceedings, mainly because it's done by the coroner. It's the coroner who has powers to require people to provide evidence, provide documents, or produce exhibits. Now, providing evidence would normally, in the first instance, be written evidence, and then, if necessary, that would proceed to oral evidence. Producing documents is obviously medical records, policies, anything like that, and exhibits as well, if necessary. Less common. Then, once the coroner has received in that disclosure, then the IPs have a right to disclosure from the coroner, provided that the disclosure is relevant. So sometimes the coroner will have a huge amount of disclosure and will only disclose to the other party them which are relevant. I just have a bit of a debate about that. I was involved in a case recently where a detained psychiatric patient was killed by another detained psychiatric patient, and we said to see the records of the other psychiatric patient to assess whether the risk that patient posed to the deceased had been able to be assessed. The trust opposed it, but the coroner dealt with it by disclosing the relevant parts of the record which dealt with risk assessment and in those parts. So the process is a kind of triangle in that the parties provide disclosure to the coroner and the coroner provides it out to the other parties. Evidence in an inquest can be written, so it's not at all uncommon for some of the evidence at a final inquest to be based on statements only, and that can be if the attendance of the witness is not possible, or there is a good reason for non-attendance, or the evidence is not disputed. It's important to note sometimes it's thought that written Rule 23 evidence can only be admitted where it is agreed. That's not right. That's one of the reasons it might be admitted, and that's quite a common reason, but sometimes it makes it inconvenient because the witness will not or cannot attend. And I have regularly made that there's no objection to that the certain evidence being read on the proviso that it's noted that it's not agreed. It isn't necessary for the coroner to read out the written evidence. It depends. If there's a jury, it almost certainly will be read out. If there isn't, then it depends on the coroner and on the judge. Sometimes they will summarise it, sometimes they will read it all out. And that can be quite important in terms of looking after clients. If there is evidence in that written evidence that they don't want to hear because it's distressing, it's often useful to remind the coroner they don't actually need to read it out because everybody knows what it says. And they can either just note that they take it into account or they can summarise what it says. At the end of an inquest, parties may make submissions. The important rule is that no party may address the coroner as to the facts. So what that means is in a civil case, I would seek to address a judge and say, this evidence of this witness is inconsistent with this document and therefore you should reject that part and you should find as a fact that X is what happened. That is what is essentially precluded by Rule 27. No one is allowed to do that. However, submissions are available. Submissions can be made on the available conclusions. So I'll come on to what those conclusions are in a minute. But if we think of a coroner sitting alone, sitting with a jury, then the coroner will, at the end of an inquest, send the jury out and essentially give them options. And they may be unlawful killing, accident, or misadventure, or it may be road traffic accident, or open, or there's various conclusions. And the coroner, in doing so, has to consider which conclusions are available on the evidence, which conclusions is it safe for the jury to reach, which is called the Galbraith Plus test. There's a bit of technical issue there about the Galbraith test and the Galbraith Plus test, which I'm not getting into today because it's a very complicated subject. Well, it can be very complicated, but in broad terms, the question is there sufficient evidence to give for that conclusion to be made? So, for a conclusion of suicide, there would need to be some evidence that the person had intended to take their own life. If it was completely unclear and there was no evidence either way, then that would not be safe for me to jury. The same process applies when the coroner is sitting alone, because the coroner needs to, or himself, certain conclusions. Conceptually, at the end of the inquest, the coroner will decide the conclusions to which I could come are accident, misadventure, or suicide, and then we'll go to consider those. Now, what is permitted is to address the coroner on which of those conclusions are appropriate, or more commonly, which are not appropriate. And in doing that, inevitably one has to address the evidence, because you have to say there is no witness evidence of this person's intention when they fell on constant train, whatever it might be. So clearly you have to address. So this is a bit of a self-contradictory process here, but most coroners are alive to it and recognise that it's very difficult to avoid addressing the fact when you're addressing the appropriate conclusions. As to conclusions, the most important thing to consider is Chief Coroner's Guidance number 17. As Chief Coroner's Guidance on lots of topics, some of it is more helpful than others, but on this topic, coroners tend to follow it quite strictly. It suggests undertaking 3 stages. This is when sitting alone, not with a jury. First is to make findings of fact, i.e. this is what happened, and if there is any dispute between witnesses, then to make conclusions on those disputes. It's still from those findings, the how, so the box 3 is on the record of inquest, and the how is a very brief description of what happened from injuries caused in a collision, in a motor collision whilst in the backseat passenger in a colored car, for example. Or it might be from internal bleeding following an operation to following an appendectomy operation. And then the conclusion goes in box 4, which has to be consistent with the findings and the how. In that conclusion can be either a short form conclusion, or it might sometimes be, or it might be a narrative conclusion. Short form conclusions, I've mentioned lots of them already. There are things like suicide, misadventure, accident, road traffic, global nature. Most of them are fairly obvious in terms of what they mean. The only one which can cause a bit of contention sometimes is misadventure. It's generally understood that misadventure is the unintended consequence of unintended. So genuinely an injury to the bowel during operation that causes bleeding and death would be described as misadventure, unless it was an extremely unusual circumstance and it was grossly negligent, and then that would be obviously unlawful to it. Narrative conclusions are the other option. The guidance says that wherever possible, coroners should conclude with a short form conclusion. So sometimes it can be an uphill struggle to persuade a coroner that a narrative conclusion is required, because that's the starting point. My usual argument in that case is even if in an example, a short form conclusion can be identified that's appropriate, it depends on the range of issues that have been identified. So even sometimes in a case that might be natural causes, if the coroner has explored a wide range of issues about the care provided to an individual, it may be more appropriate to record that somewhere in the record of inquest. A general view these days is that can be done in the findings of fact, or in box 3, or in box 4. If the narrative is reached, the guidance says it must be brief, neutral, and factual. We'll come back to Article 2 cases later. It must be directed at the central issues and nothing more, and only include matters which have more than minimally, negligibly, or trivially contributed to the death. So it cannot include things that are not relevant to the death. Longfield Care Homes is a case that confirms that narrative conclusions are not only available in Article 2 cases. And this is, as I said a moment ago, the argument that I often make, which is that sometimes a simple verdict of death by natural causes is inadequate to describe what the jury truly found. And often where there's more than one cause, narrative will be required. And neglect is something I'm going to, again, cover fairly briefly, because if we get into it, it's incredibly a subject. In a sense, so neglect is not usually a conclusion in its own right. It is usually something which is alongside something else. So it might be natural causes contributed to by neglect. It might be accidental misadventure contributed to by neglect. The most important thing to note is that the threshold for neglect is very, very high. It requires there to be a gross failure to provide adequate nourishment or liquid or basic medical attention or shelter. So it's originally starvation or the complete absence of any medical attention or shelter or warmth. However, it's not just cases where there's no action taken. It can be cases where some treatment has been provided, but it's the wrong treatment. But on the other hand, not every incorrect medical treatment is neglect. So if someone's in hospital and reasonable efforts are made to identify what's gone on, and they don't identify the internal bleeding, for example, that is not necessarily neglect. That's highly unlikely to be neglect. Neglect is very unusual finding in inquests. And it's important to note that the neglect must have made a contribution to the death that's not seen. Regulation 28 is what is also called Prevention of Future Death Reports. Now that is, that's what Regulation 28 says, is that where anything revealed by the investigation gives rise to a concern that deaths will occur, and in the coroner's opinion, action should be taken to prevent that occurrence, then the coroner must report that matter to someone. So what really happens is if the coroner thinks, look, this process is not good, it's presenting a risk of death to other people, so I'm going to write to trust or the police or authority or whoever it might be and say, you need to take some steps. The coroner can, in theory, write and say, I think these are the steps you should take. More often than not, they will write and say, I think you need to take some steps. What steps they are in a matter for you. As far as we're concerned in terms of clinical negligence, much like the conclusion, it doesn't really have any direct impact on what we do in any subsequent litigation. It can be tactically very useful, as can the conclusion, but neither impacts on anything. So, and it's not uncommon if a coroner in an inquest finds that a death is completely unavoidable and all the clinicians did everything that they possibly could to try and identify the source of the bleeding and isolate, then fine, that's the coroner's conclusion, but it did not in any way preclude proceeding in the neg context, and even the court in that context having a trial and making a contrary conclusion. Absolutely fine. The presence or absence of Regulation 28 letters similarly is not relevant, but obviously it can be tactically very helpful, as can the conclusion if the coroner finds that there were failures. So Article 2, I'm going to cover fairly briefly because, as I said earlier, it's a very big topic. Article 2 is as I'm sure you appreciate, the right to life. That's just a case which you can look at about the jurisdiction of Article 2. It's not usually going to arise in our sorts of cases. It has 3 limbs. It's sometimes looked at in different ways. My view is to look at it in terms of 3 limbs. The negative limb, so not to take life, that is, I would say, engaged where the police are involved in it, where a member of the public is shot, for example. The positive duty to take steps to safeguard lives, and the procedural duty, which is to investigate. I'm not going to talk about the first one today. The second, which is the positive duty, has 2 parts to it. That is a duty to provide a regulatory framework. So that is a system of hospitals, ambulances, police, and the regulation of those professionals. And the second is what we call the operational obligation, which is to take specific measures in an individual case where there is a real immediate risk to the life of an actual individual person. So that would be steps by police or by a hospital or a doctor or whoever it might. The systemic duty is very broad and high level. It's criminal provisions to deter offences. It's legislative steps. It's not often going to arise in the context of clinical negligence. The operational duty arises, Raybone's still a key case, where there is a real risk to life and where that risk is immediate, which is present and continuing. It's worth having a look at Raybone and the cases that follow it. Again, don't want to get too far down into this topic, but that operational duty only arises in relation to certain people in certain contexts. So in Raybone, it was was following from a line of cases that said that detained psychiatric patients were owed this operational duty. Raybone, the deceased, was not detained, but she was at risk of being detained. She was an informal patient who could have been detained if the trust had wanted to. So the court considered that she was effectively very similar to a detained patient. So that's a kind of pictorial summary of what I've just explained, which is that the right to life is protected by law, and there's substantive duty, not take life and to protect life. That's divided down into the systemic and operational duties. If there is a potential breach of any of those, then there is a procedural duty to investigate those potential breaches, and that's where the inquest process comes in. So, if there's any reason to suspect that any of the other obligations have been breached, i.e. the negative obligation or one aspect of the positive obligations, that suspicion engages the procedural obligation to investigate the death. That's what we mean by saying in an inquest that Article 2 is engaged. It's sometimes said wrongly that a coroner is invited to engage Article 2, that it has to decide to engage it. That's conceptually wrong. It is either engaged by the facts of the case or it isn't. The most common of this which arises in the neg is going to be the operational duty in terms of self-harm, involved in lots of cases of patients who are either informal or detained who've been granted leave in the grounds of the hospital or Section 17 leave and who have at that time taken their lives. Exactly what happened in Raybone. She was granted weekend leave, although she was informal anyway, and while she was on leave, she took her own life. So Raybone said that the operational duty arises or is potentially available where there has been an assumption of responsibility for the individual's welfare and safety. There's a paradigm example being state detention. But that's not the only example. State detention is not the only time it applies. And of course, as I say, in Raybone, technically, she wasn't detained. Or circumstances of sufficient vulnerability, such as where a local authority fails to exercise its powers to protect the child. And it has to be where the risk is exceptional, not ordinary risks of everyday life. And now, the risk of suicide and self-harm is, risk of death and self-harm, sorry, or risk of suicide is an exceptional risk. There's a more recent case that says, a case of AB in Worcestershire that suggests that the operational duty only arises when there's an assumption of responsibility being appealed to the Court of Appeal, and it's wrong for a whole host of reasons, which I can explain another day. But essentially, don't worry about it. It's definitely wrong. Continuing in Raybone, the operational duty was engaged there, even though she was informal, given her degree of vulnerability and the assumption of responsibility by the fact that she'd been taken in inpatient. What about a patient in the community? There's a case called Lee, which says, yes, possibly. My view is, yes, subject to what's going on, and the case depends on the extent of the involvement of community services. But, for example, if the home treatment team is seeing somebody very regularly, maybe every day, they have powers to seek attention of that person. They decide not to exercise those powers, then arguably the operational duty is engaged. Not been fully tested yet, but I don't see a reason why not. As I said, when we looked at the flowchart, there is also a systemic obligation. Now, in healthcare cases, that's very unlikely to arise because of the case of Fernandez. And I'm not going to go through this in great detail, and you can read this if it's particularly important, but the most important thing is that Fernandez says that the systemic duty is only engaged in two types of cases. One, where the patient's life is knowingly put in danger by denial of access to life-saving emergency treatment. Now, that's plainly unusual. And there is systemic or structural dysfunction, i.e. a patient deprived of assisted life-saving emergency treatment. Now, one area which this might theoretically arise is a patient waiting in a queue to get into an A&E unit, as we've seen in the news recently, subject to establishing that that's the result of structural dysfunction and not simply extremely high demand. That would be a very interesting argument, but it's at least a possibility that that's the kind of circumstance that might be being envisaged. That systemic dysfunction can be at a local level, i.e. the trust. It doesn't have to be at the state level, but it does have to be structural, not individual people making judgments that are wrong. That's not a structural failure. So in Takushi and Humberstone, there were failures in the systems of the ambulance services, i.e. the systems of allocation of resources or assessment of patients. That's a structural failure. So the point is, it's about how the structure process, the actual process itself, not how it was operated. If it was operated wrongly on one day, that probably does not engage Article 2. So why does it matter? If we say Article 2 is engaged, what difference does it make? Well, this is the investigative obligation, which is the obligation that arises, and the purpose of it is to secure the implementation of the domestic laws. If Article 2 is engaged, there are certain minimum requirements the inquest that the process has to follow. Normally, the process is done by the inquest, but it isn't always. So sometimes it might not be necessary because there's been full investigation, most commonly by inquiry. But it has to be independent, it has to be effective, there has to be sufficient scrutiny, and there must be sufficient involvement of the minimum requirements also include that the obligation is not satisfied merely by awarding damages. That's the case of Palestine. The authorities must act at their own motion. So, applying all of that to inquests, as I outlined earlier, the question becomes wider if Article 2 is engaged, being just how, but how and in what circumstances. So it can include wider matters, such as the structure, potentially issues of funding or policy that wouldn't normally be investigated by a coroner. Kent County Council, though, says the extent to which the narrower call of inquest would differ is perhaps debatable, because generally speaking, coroners will investigate all matters which directly relate to the death. So in the ambulance example I said, if there was a systems failure which led to a death, then that system would be investigated by the coroner, most probably, even in a non-Article 2 case. And as I've noted before, how is not just the last link in the chain. It is a wide discretion for the coroner, and most coroners will investigate everything that leads to that last link in the chain, even in a non-Article 2 case. So there are lots of cases where the scope will be exactly the same, but potentially cases where there's resource or policy issues. The other significant difference with an Article 2 inquest is the conclusion. And in Article 2 inquest, it must be an expression of the jury's conclusion on the disputed factual issues at the heart of the case. That principle applies whether there's a jury or not. It doesn't matter. It has to be an expression of the disputed issues at the heart of the case. Now, that's why in an Article 2 case, it's quite common to see a narrative conclusion. It does say here, in some cases, a traditional short form verdict will be satisfactory, but it must be for the coroner to decide how best to elicit a conclusion. And it's often easier to persuade a coroner to reach a narrative conclusion in an Article 2 case. So, by way of example, in Armin, the deceased was sharing a cell with someone, with his murderer, and although unlawful killing was technically appropriate, it did not deal with the major issue, which was, how did that come to happen? How did they come to be in the same cell? The form of that conclusion is, in terms of thinking about the form of the conclusion, the questions are, what are the issues? What's the breach, potential breach? Does a short form conclusion actually record that? And note that in the coroner's guidance, it says that frequently a narrative will be required in Article 2. Now, does it matter for the purposes of criminal negligence claim? As I said earlier, no, it doesn't. It doesn't make any difference at all as a matter of law what the conclusion is. But clearly, tactically, it does. And if a coroner is conducting a thorough investigation and finds on the balance of probabilities there was a failure to identify deterioration or whatever it might be, it can be very persuasive when you come to civil proceeding later. There is some debate as to whether or not the conclusion in an Article 2 case can be judgmental. Middleton did use the phrase a judgmental conclusion. Interestingly, there's a list in the coroner's guidance of permitted words, which might include inadequate, insufficient, lacking. That list of words doesn't come from Middleton, it doesn't come from anywhere else. And there's been criticism more recently, in a case called Smith, of conclusions which are too critical and go too far. My view is that it's appropriate for the coroner to find that there was a failure to, for example, identify that the patient was bleeding, because that is fact the coroner is entitled to find. That doesn't establish civil liability. But perhaps words like inadequate, inappropriate, insufficient may be too far. It does depend really on the circumstance of the case. The other issue in terms of Article 2 inquests is in relation to causation. In Lewis is a case that says the coroner has a power, but not a duty, to leave matters to the jury if there is evidence which they can conclude that matters were possibly, but not probably caused it. And that's only available in Article 2 case. And that can be a significant. Humberston is a case about legal aid funding, which says that the decision of the legal aid agency has to focus on the participation of the family. They must be involved to the extent necessary to safeguard their interests. And this refers back to the Alsvini requirements on Article 2 inquest that I referred to earlier. It notes that it will often be difficult for families to ask questions if they're not represented. So, although the reality is I don't get involved in applications for legal aid, I know from my experience that it's much easier to get legal aid for an inquest if Article 2 is engaged. It's not absolutely certain, but it's quite common if it's engaged, subject to assessment of means. If Article 2 is not engaged, it is much, much harder and being very, very difficult indeed to get legal aid funding. So, some good points, and possibly one that's very important to those that are in civil litigation field is costs. Roach is still the primary case on recovering costs of an inquest, and the kind of point is that you can have, in theory, the costs of attendance of an inquest recovered as part of the costs of the subsequent civil proceeding. It really all depends on whether they are properly considered to be part of that civil proceeding and part of the investigation of those proceedings. Because, and what they said in Roach was that the Home Office in that case, when there's a prisoner death, would have admitted liability, which would avoid or minimise any potential liability for costs, because there would need to be involved in the inquest to establish liability. And the court noted that inquests in practice in this case seem to have had the effect of causing the civil proceedings speedily to be compromised, because as a result of the inquest, it was very clear that the Home Office were liable for their commitment that the case could be. So really the question is, are the costs of the inquest reasonably incurred in the process of investigating and establishing the claimant's claim in negligence? Now, even though, as I said earlier, the conclusion is not relevant to the conclusion of the civil proceeding, the investigation clearly is, and the investigation is designed to establish the facts of what happened. So if liability is not known or committed, then it's necessary for the claimant in civil proceedings to participate in the inquest to find out what's happened. That is the logical process. So in more recent cases, Veevers and the Greater Manchester Fire and Rescue Service, where they tried to have it both ways. The defendant said that they would not admit liability, but that they would pay damages and would not unethically threat. They were asked to make an open admission, but they refused. on assessment of costs, the court said that was not sufficient as it was drawn, and therefore the costs of attending the inquest were in principle recoverable, subject to proportionality, etc. So this makes clear that only an actual admission of liability will be sufficient. And the difficulty, of course, is I've had a number of cases where trusts have admitted liability, in one case very shortly before an inquest, for this purpose, in order to prevent the claimant from recovering the costs of attending the inquest. So I often suggest thinking very hard about whether we want to send a letter of claim. There's the difficulties. If we send one, that risks a letter of response admitting liability, which will prevent recovering the costs of the inquest. So sometimes it can be beneficial not to send one, if that's an option, depending on limitation and everything else. And of course, the other thing we have to always consider is proportionality, because some fatal claims very high value, some very low value. And if they might be very low value, but the inquest is going to be very long, it may, even though it is in principle recoverable, it may not be proportionate. So a couple of final kind of practical tips and thoughts in terms of civil litigation and the inquest. As I said earlier, disclosure is always going to be via the coroner, and disclosure has to be relevant to the full question. But also bear in mind the coroner has Regulation 28 obligations. The parties are perfectly entitled to submit to the coroner that certain matters should be disclosed or witnesses should be approached. So it's perfectly normal to say to the coroner, well, we think that the anaesthetist should give a witness statement and explain their involvement. And this is an opportunity to seek information about what happened that you would not normally get in the civil proceedings just from a letter of claim. If you want to hear the surgeon's view on what happened, then you'll hear it in the inquest, and you wouldn't obviously normally do that. If you want to hear what the trust policy is on someone's, you can invite the coroner to obtain that policy, provided it's relevant. So you can use this as an opportunity to start gathering information, as long as it's always relevant to the full question, because our job in an inquest is to assist the coroner, even though what we're getting might assist us in other ways. We always have to focus on what we're doing in assisting the coroner, and then they are much more likely to be willing to do it. The inquest, obviously, I would hope that you'll normally have experienced inquest counsel deal with this, but my feeling is that the coroner will sometimes restrict questions because the coroner is not investigating your liability case. However, the question of how or how and in what circumstances, very often, if not always, will align with your liability investigation, because you're looking at whether negligence caused death, coroner's looking at what caused the death. Don't be surprised if you hear witnesses give opinion evidence. It's very common. Even clinicians who were involved are asked, do you think that that's normal? Or they have to comment on each other's care. Yes, technically they're not independent, and I might invite the coroner to bear that in mind when considering what they've said. But as a general observation, the vast majority of those doctors that are asked to do so honestly and straightforwardly, and I have many occasions heard them say, I don't think that that's the right thing to do. So you can ask witnesses whether you think that something should have happened, whether they're surprised that something happened, whether it's normal, whether it's not best practice. The Burnham test doesn't apply, but you can ask about what usual practice, what should happen, because even though the coroner is not investigating liability formally, the coroner will want to explore what should happen and whether anything has gone wrong for two reasons. One, Regulation 28 letters, and two, because in order to reach a conclusion, it's necessary to understand whether something ought to have happened or whether there was an opportunity to identify probable cause of death. Because that's the difference between, for example, medical causes or misadventure, or very unusually, mortal killing. So hopefully that is a useful and very quick run through what an inquest is, how it works, and how we can use them to our benefit in civil proceedings. Very happy if anyone has any questions and wants to do in the chat, fine. If you don't want to do it in the chat and want to ask me anything privately, then my email address is available. And I'm very happy to pop me an email and I'll answer it that way.